Have a landlord asking if their rental increase is lawful or not. And we'll go through the facts. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos here. Now, let's set up the facts here. This landlord here had a lease in 2024. I guess they rented the property initially for $1,000 a month. When the lease expired, they renegotiated a new lease for $1,700 a month. Okay. Can't show the math on these on the TikTok video, but it's a $600 difference. Okay. I plug that difference into my calculator. $600 divided by $1,100. My calculator spits out a rental increase of 54.5%. Okay. And is that lawful under the Tenants Protection Act of 2019? I'm going to assume we're talking about Tenants Protection Act of 2019. That would be Civil Code Section 1947.12, at least for rental increases. Okay, we'll start our analysis there. Also, what's noted not in the comment is, I guess this landlord here is now doing an eviction for non-payment of rent for 2 months worth of rent from August and September 2025 at the $1,700 rent, and the tenant is claiming a defense to in this eviction based on the increase of rent, and that's where our comment left off at. I'm going to assume that the defense the tenants are raising is the rent was increased above lawful limits. Okay. So that's the defense, and it's an overstatement of the rent. The landlord can't charge me a 54.5% increase. Is that lawful, Rob? And that question is really going to depend on a number of different factors if this is subject to the Tenants Protection Act, okay? Because generally speaking, a landlord cannot raise the rent more than 5% plus the change in CPI, or no more than 10% unless they have an exemption to the Tenants Protection Act of 2019. Okay, and landlords, remember that for under Tenant Protection Act purposes, the exemptions for rental to the rent caps under Civil Code Section 1947.12 are limited. They're less exemptions than there are for just cause eviction. Okay, so for example, this landlord could raise the rent at 54.5% if, for example, they are exempt under 1947.12, which are the exemptions are as follows: the deeds restricted by, they have a restricted deed basically for affordable housing, and there's a whole line under the Health and Safety Code 500903 of the Health and Safety Code. If you have an agreement or your housing restricted for very low housing, that type of deal, that would be exempt. If you're a dormitory owned by a higher education or educational institution, you'd be exempt. The most common exemptions would be for a certificate of occupancy issued within the last 15 years. So if this owner, for example, had new construction, that dwelling, that she rented out to the tenant is built within the last 15 years, that's exempt. Okay. And then there is the single dwellings exemption, for your single family homes, condos, that type of deal. If that's new construction, or a single dwelling, your single family homes, those are exempt under the Tenants Protection Act. Okay, so there is one last exemption that might apply. We'll go over those. Would be a property containing 2 dwelling units in a single structure. Okay, like a duplex, for example, that has a shared wall. Okay, owner lives on one side, the tenant lives on another. If that was the owner's principal place of residence at the beginning of the tenancy, and so long as the owner continues to reside there, that could be an exemption. Okay, so under these circumstances, this long-winded answer to Kai's question here is, if her building was built within the last 15 years, or if the property is like a duplex with a shared wall. Okay, not a detached unit. It has to be shared wall within a single structure. The owner occupied that unit and they rented the property while they were living in the duplex as their principal residence, that would be exempt. Okay. If none of those exemptions apply, then the tenants actually might have a viable defense in this case, where the rent was increased by 54.5%. I know they were done by lease agreements and so forth, but it is, the Tenants Protection Act would apply in this case because the tenants have resided there previously. Even though there's a separate lease agreement, there's that argument of, hey, the rental increase is unlawful because they raised the rent within over the limits prohibited in section 1947.12. That's a viable defense, I think. So more of the story is, and I'm sorry, this one was long-winded here, okay, is landlords, if you're going to contemplate doing an eviction for non-payment of rent, you need to know ahead of time if your rental increases are lawful or not, because the two things that will derail you in a non-payment of rent case is unlawful rental increases, that exceed the legal limits, basically, and habitability issues. That's what I tell my landlords all the time. You want to know that up front. And when if you're a landlord, you come to our office, we do an analysis every time, because you don't want your tenants to argue this in court and then possibly lose the case in court because your rental increases exceed the legal limits. So, if you're a landlord in the Northern California area and you're facing a non-payment of rent situation and you need to make sure your rental increases are lawful before you go to court, feel free to reach out. We might be able to help out. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.